Hi. Before I get started, I'd like to acknowledge the Larrakia people on whose land I live and study and pay my respect to elders past, present and emerging. I'd also like to issue a warning that there are images of people in this presentation who may have passed away. Indigenous peoples from all corners of the world have been subject to harmful effects of colonisation. Both the Sami people of Northern Europe and the Aboriginal and Torres Strait Islander peoples of what is now Australia have historically had extremely strong connections to land and sea through their culture that has been disrupted by colonial settlers. Over this time, various legal frameworks have been implemented, initially to assimilate the Indigenous people into settler society and eradicate traditional culture, until progressively both nations have initiated changes to try and preserve or restore some of what they have damaged, with varying degrees of success. The Indigenous people of Australia have inhabited this continent for at least 65,000 years. There are over 200 language groups or nations that were here before the European invasion. The map here can give you an idea of this, with each of the words representing a language and the rough area of land where that group lived. The groups are very diverse but are linked by a connection to country, the land and sea where they live. In most, if not all nations, culture and country are inextricably linked, and a separation from country means a direct disruption to the practice and survival of that culture. With the beginning of the European settlement and the declaration and subsequent discourse of terra nullius, these connections were damaged or severed to varying extents across the continent. The harm to Indigenous cultures, including their connection and rights to land and sea, continued in the colony, from the frontier wars to the White Australia policy and the atrocities of the stolen generations. More recently, the government has attempted to acknowledge some of the loss caused by these colonial settlers and begun to introduce tools for the reacquisition of land by traditional custodians. We'll get into those a bit later. The Sami people are the Indigenous people of the far north of Europe whose traditional home, known as Sapmi, cover the 4 current nation states of Norway, Sweden, Finland and Russia. The highest proportion of the Sami population live in Norway, with an estimated 70,000 people. Sami people place great value on the natural environment, and they view man and nature as a unity. Sami were a semi-nomadic people who did not individualize use of the land, but collectively used it for things such as reindeer herding, hunting, and fishing, and would traditionally follow seasonal migrations. The borders introduced by the kingdoms of Sweden and Norway restricted movement of Sami people and hindered their traditional resource use and way of life, and also forced Sami to become citizens of one of these nation states. During the 19th century, as agriculture was expanding, Norway wanted more space for development and looked to the north, where they thought the land was either unoccupied or underutilized. Because Sami people did not have the same concept of land ownership, just like in Australia, the land was declared terra nullius, and the traditional grazing rights of reindeer herders was obstructed by the government. Following this, the rights of Sami got less and less. They introduced the Norwegianization policy, which included banning the use of Sami languages in schools and restricting the purchase and ownership of land to only people who could read and write in Norwegian. After World War II, a more liberal attitude began to expand among Norwegians and continued to develop until the 70s, when the proposed construction of a dam in the Kautokeino outer river was met with protests of environmentalists and Sami people together. Although the project went ahead, it resulted in an amplification of Sami rights, leading to the Sami Rights Commission and the Sami Cultural Commission, which were both established in 1980. The Sami Rights Commission had a wide scope and included the duty to examine questions concerning Sami rights to land and water. The Commission raised doubts about the basis of state ownership of traditional Sami land and suggested the incorporation of the Sami Parliament. A full report was accepted by Norwegian Parliament in 1987 with the inclusion of the Sami Act. The purpose of the Act was specified to enable the Sami people in Norway to safeguard and develop their language, culture, and way of life. The main tool for this to happen was the introduction of the Sami Ting, or Sami Parliament, in 1989, which could deal with any matters that affect Sami people. The Sami Parliament is comprised of 39 elected representatives who are voted for by individuals who choose to register on the Sami electoral roll, which can be anyone who perceives themselves as Sami and has Sami as their home language, or has a parent, grandparent, or great-grandparent with Sami as their home language. The Sami Parliament has had a strong dialogue with the Norwegian government since its inception, providing advice and debate on matters that affect them. The Norwegian ministry also delegates an amount of money with which Sami Parliament can decide what they do with. Although the Sami Parliament is supposedly and essentially the Sami's own government, it is still bound to the larger Norwegian government, and so autonomy is somewhat limited. Developmental and environmental projects that affect Sami land areas are legally required to consult with the Sami Parliament. In addition to the Sami Act, the Norwegian government extended their recognition of Sami as traditional owners with the 2005 Finnmark Act, which was negotiated about with the Sami Parliament. The Act transferred 95% of Finnmark, which is that yellow county right up the top there, the largest county of Norway within Sápmi, from a state-owned enterprise to a new entity, Finnmarkseiendommen, or the Finnmark Estate, which was to be governed by a board of people, 3 from the Sami Parliament and 3 from the City Council. The purpose of the Act was to facilitate management of the land and natural resources in the county of Finnmark in a balanced and ecological sustainable manner for the benefit of the residents of the county, and particularly as a basis for Sami culture, reindeer husbandry, use of non-cultivated areas, commercial activity, and social life. It recognised that Sami have explicit rights to this land, which have been acquired by long-term use, but extends the rights to all current residents by being ethnically neutral, while still paying regard to particular Sami interests. So it's regulated the management of the land and its resources, while providing the Indigenous people the right to benefit from or share those resources. So in Australia, from the time of European invasion, Indigenous peoples have been maintaining their sovereign right to the land and waters which has never been ceded and for which a treaty has never existed. Although the rights of First Nations people have largely not been recognised by settler colonial society, some strides have been taken in legislations in an attempt at acknowledging them as the traditional owners. This in itself can be a problematic lens to look at the issue with, because like Sami people, Aboriginal and Torres Strait Islander people tend not to look at country as something that is to be owned and divided up in the Western sense, consider a more natural coexistence of people and nature. It's more about connection than ownership. So Indigenous people have been forced to try and translate their knowledge and connection to a Western framework in order to regain traditional connections. One way in which First Nations peoples asserted their sovereignty in a way that was more in the line with the ideological way of the English was with the Yirrkala Bark petitions in 1963, which were presented by the Yolngu people to the Australian Parliament in opposition to bauxite mines being developed on their country. Not long after this, in 1966, the Wavell walk-off happened at a cattle station in the NT, and Vincent Lingari fought for rights to his homeland. These events and others around this time were significant in setting the scene for the government to pass tangible legislation such as the Aboriginal Land Rights Act in 1976, which was applicable in the Northern Territory. Land rights meant specially created Aboriginal land trusts would hold the titles to Aboriginal lands. To acquire rights to particular land, there had to be a demonstration of a customary relationship, and the land had to be unalienated from the Crown. This act resulted in around 50% of land and 85% of coastline in the Northern Territory being recognised as owned by First Nation groups, including Uluru, Kakadu and the Tiwi Islands. In the 80s and 90s, the Mabo case was in the High Courts, and the people of Mer, or Murray Island, as seen here, succeeded in getting recognition that terra nullius was a falsehood, and Murrian people have traditional rights and obligations to that land. The case was important in setting the precedent that Indigenous peoples had been in Australia for many thousands of years and were entitled to the traditional lands according to their own culture and law, and led to the Native Title Act being passed in 1993. The Native Title Act recognises that traditional ownership may exist, but substantial proof of continuous connection through law and custom to the land is required, since before colonisation. This can obviously be a troublesome task for many people who have been dispossessed of the land directly due to that process of colonisation. If native title is achieved, it generally gives people the rights to go onto the land and stay there, perform traditional practice, for example, ceremony, hunting or foraging, and to negotiate to an extent against certain developments on the land, but it does not give exclusive rights. So miners, pastoralists and government departments, for example, may still be allowed to use it as they want, although native title holders may then be entitled to some compensation. Since the Act's introduction, more than 32% of the Australian continent has been recognised as having native title. So the Sami Parliament is the key to the success of land rights for Sami in Norway because it gives a real voice to the people themselves, rather than how it is in Australia, with the government trying to sort of guess what is good for Indigenous people while barely including them in conversation. The need for an Indigenous voice in Parliament in Australia was expressed in the Uluru Statement from the Heart, and the open dialogue that happens in Norway would be a good example from which to learn. Neither system is perfect, as even in Norway there are presently disagreements about a large wind farm being developed in Sápmi reindeer country, and there are still disputes about fishing in Sámi waters that have not reached agreement between the Sámi and Norwegian parliaments. However, the Australian legislation, in particular native title, has unreasonable hurdles for Indigenous people to achieve. The rights appointed by the state do not live up to the ancestral rights, and too often claims are extinguished, with no responsibility by the settler colonial state that they are the precise reason that continuous practice on the land was disrupted. It also provides legitimisation of the dispossession when those claims are extinguished. Both the Finnmark Act and native title claim to be for the preservation of disrupted cultural practices, connections to land, but both also provide loopholes for outside parties to interfere. In Australia, it's more for miners and pastoralists, and in Norway, sustainability plans have been an excuse for those wind farms just mentioned. Although issues still exist in both countries, the legal framework in Norway is more effective in procuring true land rights for the Sámi people than the administration in Australia, because they have a vehicle with which to say what that truly means to them. Thank you.